Okay, we're almost there. The last question that continues to come up, in fact, it came up so much, the association was kind enough to ask me to help with the Q&A, is what do you do if a guest refuses to wear a mask? I'm not going to go through all of this today because I think that you can read this and get some information yourself. But I wanted to let you know that we did put something together. So it runs through everything, which is basically, regardless if somebody is asserting that they have a medical condition or not, you just need to be ready with some form of alternatives. So it might be hard for a spa treatment, but rescheduling somebody's service or providing an alternative treatment. If it's a restaurant, you would say that they could do curbside or takeout instead of dining there. That's pretty much going to help you with the potential legal claims under the Americans with Disabilities Act. But also go ahead and just read this. I think it'll give you more of the information and walk you through it. And then the association or I are available for questions. So I know I've only got 5 minutes left, but I am happy to take any other questions that you might have, or let me know if you have one and we can certainly get back to you later.
Okay, I've got a few questions coming up here. Let's start with Susan. What if you have an employee that you know is at high risk with a few factors, but you know they don't want to bring it up and want to work?
So I'm presuming, like, let's just say we have a 66-year-old person working for us and we know that they had a heart attack last year. I'm making up the hypothetical.
Sure.
Believe it or not, you actually don't have a duty to go tell them that they can't work. If you start sending them home because of that, you do run into a disability discrimination lawsuit. I mean, this one's a little bit more subtle in the practical answer for how to handle it. I mean, the legal answer is you don't have to tell them anything. The practical answer might be that you will go ahead and have that conversation there and ask them if they've reached out to their healthcare provider to find out if it is okay for them to come at work, and then you probably want to make a note of that.
Okay. Got another question here from Dan. With my business being temporarily closed due to COVID and my employees receiving unemployment benefits based on standby status, will my business's ESD experience rating be raised?
That is a technical ESD question that I cannot answer.
Yeah.
Sorry, I'm smiling because there are some things I don't know.
Okay. And we might have a future webinar to talk about ESD type topics. So Dan, stay tuned for that.
Yeah.
Another anonymous question. When your employer has you take a 20% pay cut, what is the law around this? When there have been does there need to be an end date stated? Is there a form that has to be signed by both employee and employer?
Yeah, sure. I can talk about this a little bit. So if you're an at-will employee, or even if you have a contract, your pay is also at will. So if you have a contract, though, where you have a certain amount of pay, that's talking about renegotiating a contract, and you're probably going to need to execute that. So let's not talk about that situation. But for a 20% pay cut, I get to tell you, I had to take a 20% pay cut with my firm because we had business concerns just like all of you. And so that was something that my firm did. They didn't have to get my permission. They did let me know. They explained to me what was going on, and we talked about the reasons. But in fact, the employer does not need to promise you how long that's going to be. They don't even need to tell you that you're going to have it back, generally speaking. Now, there may be some technical issues if you're a salaried employee and your salary is getting reduced, but generally, the minimum salary test under federal law is less than 784 now. So there's a lot of flexibility where you still remain an overtime exempt employee. I would say that it is a good practice to communicate with your employees the reasons for this, how long you anticipate to be going on, and what is happening. But there is no law that says you can't change an employee's pay unless we've got a contract or an enforceable written agreement. So the real answer to this might be a little bit more subtle than the general guidelines I gave you.
Okay. Those are the only open questions we have. Any final thoughts, Catherine?
Well, I know that all of this feels like we have to become healthcare providers now. And so I think that the guidance I want you to give is, yes, it feels that way. So reach out for help to get it right. I think the takeaway for me when I look at all this is that I want to be relying on information from a healthcare provider, even rather than trying to work through the CDC guidelines myself. And that's what I'm working with when I work with clients on this for exposure. I think when in doubt, err on the side of safety. I do think that that there are reasons to consider having a travel, automatic quarantine if you're dealing with those issues. I do think sometimes that I guess if I had to give some general advice, is employers or managers look to a policy to do the management for them rather than having a conversation with the employee. One of those Vegas examples I gave, in fact, having a conversation with the employee about how they were putting their coworkers at danger and putting them at risk, ended up taking care of the problem. So, be open to that. Conversations and communication is what this is going to be all about. These are tough times, and everybody is faced with challenges, a lot of misinformation and too much information. So the association is a great resource. They can certainly point you to things. I am available during advisory network calls if you think it's something where you might need a lawyer as well, or hopefully you've got counsel that you work with.